Okay. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. We will hear today in the matter of Plessy versus Ferguson. Petitioners, the floor is yours.
May it please the court. Honorable Justices, the laws of this nation do not exist in a vacuum. Meritocracy, being the great game of this nation, cannot succeed if the playing field is unkept and the referees are paid off. If this country should side with the respondents, separate by equal will surely spread throughout this country. Our society will split into along racial lines, and colored races shall surely be the inferior. As I say in my brief, this shall be a caste system, unrecognized by this court, but a caste system all the same. It shall be the fall of our meritocracy and all the values we hold dear, life, liberty, and the pursuit of happiness. The violation of Plessy's constitutional rights is representative of a much larger national issue. We implore the court to give careful consideration to these facts.
Start off.
All right, cool. I have a question. So in your brief, you lay out your three main arguments for the case, and I have a question about number one, in which you say no law may stimulate racial prejudice.
Yes.
And I want you to explain to me where you get that.
All right, so we get that from Strother, West Virginia. When we read this, at first there was some questioning about whether this was over the dictum or not. After going through the full ruling, I can confidently say it was not over the dictum. But what it says, well, I can read the full quote, the full sentence if you would like. He's basically giving a reason, like his main reason for why it's unconstitutional. He says, the very fact that the colored people are assigned out and are singled out and expressly denied by a statute all right to participate in the administration of the law as jurors because of their color, obviously relating it back to the main dictum. Though they are citizens and may be in other respects fully qualified, it's practically a brand upon them, affixed by law, an assertion of their inferiority, and a stimulant to that race prejudice which is an impediment to securing to individuals of the race that equal justice which the law aims to secure to all others. So what this is saying is basically that the law, the 14th Amendment, its aim is to secure equal justice to all races. And that's clear just by looking at the history. And it's saying that to stimulate that racial prejudice is one of the main things that made the Strother case, that made them side with Strother in that case. One of the other main things was because it is a brand upon them affixed by law of their inferiority. So those two things are the main reasons for why Strother went to that side.
I think though that you are, if I remember correctly, your second point was no law may assert the inferiority of any portion of society. So I would actually see it as problematic that you're making one and two separate things that can be violated, that if violated would make the law unconstitutional, because here we see that both 1 and 2 are talked about, but they're talked about together. It doesn't say if this or that happens, that it's unconstitutional. So I don't see why those would be separate here, but...
You'll continue honorable justice.
Okay, thank you. And the second thing I would want to ask, why don't you go first and I'll ask you the follow-up.
You'll see that in my brief, I do recognize that it says it does not separate the two, and that I do prove that both are violated in my brief, and I do agree with you that the two have to be violated in order to
Together.
Yeah, and I prove that both are violated.
Okay. So you say that no law may assert an inferiority of any portion of society. Why are you so certain that this law does that?
Well, there are, of course, a lot of reasons why this law, and to figure out if a law is a certain inferiority is difficult to undertake. But what you have to do in order to see that is to see, basically, to see the reason this law was implemented, the concrete effect of the law, and I guess those are the main two.
I think the respondents would argue and have argued that it's possible that this law was enacted for the safety of both of these parties, and it's possible that both of the train cars are equal on its face and that no one feels different in either of them. Would the law still be fixing a brand of inferiority then?
I think so, and I think that this case extends beyond police power. In the short term, while it may be peaceful, it's just going to create more issues in the nation in the long term to separate Black people and white people, especially in a time of such violence. I actually think it's detrimental for the nation to separate.
Is a law responsible for that though? Is a law responsible for its long-term consequences?
Police power
Well,
is.
it's not
Police power is meant to ensure the safety of the people in a specific area, and I actually think this is detrimental.
And you'll see what they say is that, what you even said that they say, is that the law was meant to help the black races, the black race, the colored races. But what you'll see if you look at the legislature, first of all, you'll see most of them are white supremacists. And you'll go back to the Constitution of 1879, I believe. Well, you'll see these same legislators, the same Governor Nichols, heading this ratification, this convention, in which what they do is they limit the rights of black people to vote by introducing grandfather clauses. These is obviously an attempt to undermine the black population. And then you'll see that this works because 47.1% of the population of Louisiana is black. Only around 10% of the population of the legislators at this time are black. So they're clearly...
Is trying to undermine the ability of black people to vote, how does that have to do with separating cars being a branding of inferiority? I just don't understand what here is the branding of inferiority.
Well, the branding of inferiority is basically you have to look at what they're trying to do with this law, and what they're trying to do.
Can you? Is it fair to take a piece of legislation and start analyzing the reasoning, the intent behind it? Can you do that when a piece of legislation is passed in a Senate by 51 members? How can you, and each probably with slightly different intentions, how can you analyze such legislation's intent in understanding whether it's a branding of inferiority? I don't think you can look at intent. I think that you need to see, is it literally, does this brand black people as inferior, and is that what it says in the law?
I think it definitely does, but regardless of the intent of the lawmakers, the enforcement of the Louisiana Separate Car Act was extremely arbitrary, and it was up to the train conductor to decide which cart each customer was to be in. And while being 1/8 black may not be arbitrary from a biological standpoint, it is if you're just looking at appearances. And the training officer also has immunity in this case, which seems to be beyond.
I have a question about that.
Could I ask about the immunity really quickly?
Sure.
Can you elaborate on the immunity, what exactly their immunity is? Because it wasn't totally clear from the, when I read the law, I didn't really understand. I didn't understand from your brief either.
Basically, it's up to the train conductor to decide who should go in what cart, and they have immunity, so they don't face consequences for
For what?
for
getting it wrong.
For getting it wrong.
So basically, the conductor can deny someone the ticket they paid for based on his own decision without any facts or anything. You can't. There's no recourse except for suing the state. And that way, it clearly is an issue with the state of Louisiana.
Okay, I have a question. So you say that no law may be administered with racial prejudice, causing the outcome to affect one race unlike the other. Do you believe, and you cite Yigbo in this ruling, do you believe that this is still true if the law provides fair and reasonable guidelines, but the enforcement does not hold to those guidelines? Like, let's say you want to build a laundry, and there are three permits, like a fire code permit that you need, and the enforcement may be discriminatory, but the law has clear guidelines. Is that law still unconstitutional?
Of course.
So if, say, the law's easier on buildings that are made of brick, then.
But the
then
law,
buildings
the
that
law
are
has
wood.
clear guidelines about what is safe and unsafe, and
No,
who
that's
can
not
have a
the
permit
problem
and
with this
not.
law.
But the enforcement is unconstitutional. Is that law unconstitutional?
That's not the problem with this law, with this.
Can you just answer my
Louisiana-
question first?
Yes,
Yes or no?
that is fine, because that is constitutional, that's not the problem with this law. This law is, basically what this law is doing is privileging the already privileged in society and undermining the underprivileged.
But I'm asking about the guidelines.
Yeah,
Are the guidelines here clear?
in this law, are the guidelines
In
clear?
Plessy versus
Yes.
Ferguson, are
The guidelines are clear, yes, but the guidelines are clear, indeed, but the train conductor has no way to know if he is following the guidelines, because in the end, what his power is to basically make a decision about the race of the individual without any proof. So although the guidelines are clear, he has no way of possibly following those guidelines.
So do you think the unenforceability of a law makes it unconstitutional?
Well, from Yikwo, we can, I think we can say yes, because the ruling in Yikwo, says that the ordinance divides the owners or occupiers into two classes, not having respect to their personal character and qualification for the business, but merely an arbitrary line. So just because the wording of a law
But
is.
Yikwo says that if the arbitrariness of the law causes the discrimination, it's unconstitutional. Are you arguing that the nature of the law is causing this discrimination?
I think she's,
Yes.
the arbitrariness, I think it's a valid argument to say that the arbitrariness of the amount of power delegated to an officer in trying to derive from their perception the genealogy of someone, that's pretty arbitrary. But I think in continuing the parallels between Yikwo and Plessy, who would you see if the Board of Supervisors is really the delegated power to to carry out, to execute the law? What do you think is the equivalent in Plessy? Is it the train officer? Is it the attorney general? Is it the train car company? Who do you see as being the body responsible for enforcing or executing the law?
So that's where the connection between Yikwo and this case get a little blurry. Because the train officer, I believe, is still an officer of the state. I don't believe he is hired by the train company, but I think he's hired by the state, but even if he's hired by the train company, he or she is hired by the train company, the fact that they are immune in this situation and the only course of getting damages for harm is to go to the state means that basically.
I would even say that's not possible. So I checked and there really is no path for redress for private litigants in this situation. So even if Plessy wanted to sue the train car company for violating the Separate Car Act because it had two cars that were unequal, he wouldn't have been able to do so. It would have to be done by the state attorney general. That's where the litigation would have to start. So that's why the attorney general is potentially an alternative enforcer in this situation to the officers. But I think.
But doesn't the attorney general have an insane amount of discretion and no
Absolutely.
guidelines for who he sues?
Absolutely. So that's what I want to ask you.
Yeah.
So do you think who is the enforcer? Is it the attorney general or is it the officer?
Well, there are more than one enforcer of this law.
Okay.
Because first it's the train company and the officer, and then it's the attorney general, and we'll see that really it's the attorney general and the state itself, which is the main issue in this case.
And if I were to rule under Yikwo, extending Yikwo basically to include the attorney general, basically saying that that this law gave too much discretion to the attorney general, does that set a problematic precedent?
Do you elaborate on that?
Would it be planting a stake in the ground that when a law that you can't give too much leeway to an attorney general? Is that not problematic when they are the supreme litigator in a state? Is that problematic?
It very well may be, because I mean the discretion is part of the power, which is why our main course of, which is why Emily and my main course of argument is not actually the enforcement. Because anyone can see that train cars were not set up properly. Even the respondents say in their briefs that, well, I can quote along, the independent train companies which were regulated under these laws failed to comply with the provisions of the law. But our argument goes beyond that. Our argument goes to basically the fact that this law, how much time?
5 minutes.
This law is, the whole point of this law, and I don't think anyone could possibly disagree with this, is to further the racial divide in Louisiana. That's what they're doing. They're separating them. They're making a greater divide. And obviously, and the legislators know this, the people of Louisiana know this, the white population who has been committing atrocities, massacres of up to 400 black people, and lynchings daily know this, and the black population knows this too. The black population, which has been putting up a passionate resistance to this law through newspapers and their churches, knows this as well. And basically, who stands to lose by furthering this racial divide, other than the historic victims of the racial divide in Louisiana, the colored races? That is the full intent, the full effect, and everything of this law. And it's really the encompassing.
Do you have a question?
Okay, I have a question. So you talked a lot about like the social consequences of this law, right? Do you think that matters?
Oh, yes, very
I
much.
think we both think that matters a lot, because you can't really have civil rights without social rights and vice versa. So they're extremely intertwined.
The entire purpose of this law is social.
But if, say, in the Constitution, social rights are not given as in the Bill of Rights, they're not given as rights, what makes you so sure that there's something that people fundamentally have?
They seem to be implied, and the Equal Protections Clause, I can quote it.
Right, but it
If-
refers
if
to
you
equal
can-
protection under the law,
Yeah.
not equal protection socially.
If you're going to say, if the respondents are going to say that you can't look at the social consequences of this, then that's as if to say you can't look at the law at all. The entire law is social. The entire law, even the purpose at which they state, is to help the social situation of the black people. That's obviously false. That's not the purpose of the law at all, nor is it the effect of the law, nor is it what the law says,
Wait, but if the purpose of the law is safety,
which is not.
But you can't prove
You-
you can't prove intent of
You need to prove
51.
effects.
You can't prove the intent of 51 legislators who came together to pass one.
but
a piece of
let's
legislation.
just assume, for now, for just a second, that the purpose of the law is safety. Is that, and that it provides a safer environment? Whether or not that's true, let's assume this for a second, and then is the law okay? If it's for safety and it does provide a safer environment, then is the law okay?
Yeah, that's fine. You're allowed to make racial distinctions in your laws. We know that from Strata v. West Virginia.
So you're saying it's only okay because
It's only problematic
because of the intent?
because we can prove that legislators are white supremacists, and we can prove that the effect of this law is to undermine the colored races.
It's anachronistic.
If
but
you
I-
like, yeah.
But I think we can, there's an example that might help us examine this idea. If we look at the war on drugs, the laws on their surface, or singling out a certain type of cocaine that is used more often by blacks in okay, let's speed up. What do you think about laws like that that are enforced unequally by police but are in that situation?
In that situation, where like the government is clearly singling out the black community,
They're not clearly. It's a law about cocaine.
well, if it can be proven that the law is the effect and the intent of the law was to single out the black community, then that is not alright by what our case is.
What if I can
And,
prove?
well, to single out and also underprivilege them, and also cut down their privilege for the
Also,
underprivileged.
Couldn't it create a problematic precedent to say that the intent of the law can undermine the law?
Yeah.
It's not just the intent though, because I say it's the intent, it's the evil eye and unequal hand, which was basically,
So you will have, we'll have a chance for follow-up, after this next round, so if you have other, you guys, if you have things you wanna further say, make sure you jot them down. And if you have other questions, make sure that you guys have them at the ready. Connie, you've got the time to reset. Excellent. Respondents, are you ready to go?
Yep.
Okay, justices, you ready?
Yep.
Okay, respondents, the floor is yours.
May it please the court, the 10th Amendment gives the states the right to pass laws that are necessary for making society flow smoothly. In our case, we have two warring races. Separation of the races is an important measure the Louisiana legislature took in order to ensure the safety and peace of the people. The Separate Car Act, far from violating the 14th Amendment rights, it is vital in upholding them. Whether the law is enforced fully or not detracts nothing from the essential righteousness of the law itself.
Okay, I have a question about safety. You talk a lot about extreme incidents, which represent only a small percentage of the population. Do you have any examples of everyday people on a train inciting acts of violence or using racial slurs or something
Why does that
like that?
matter?
It matters to me, I'm asking.
I don't have any specific examples, but I think the separation of the two races can avoid any incidents that may occur between the two races that
But you can't provide me an example.
It's not our job to evaluate whether the law is
Wait,
effective.
wait,
Well,
I'm just asking, I'm just asking.
In McCullough v. Maryland, that's a bit of a precedent that applies to this case. It's not the court's job to decide whether the legislature is passing measures that are good to solve the problem, only that they are constitutional. And this law is constitutional.
I was just asking.
I want to get back to the idea of branding that the petitioners brought up. Do you believe that dividing train cars into purebred white, defined as having less than 1/8 other blood, and everyone else, anybody with 1/8 or more Black, Asian, Hispanic, Native American, other blood, does that create a brand of inferiority on members of the colored car?
No. If anything, it might create a brand of inferiority on the whites. And it's the same thing, you're just
Is it not
dividing
usually that the smaller group, the more exclusive group, is the one that's considered superior?
them. No,
Is that not grounded in social understanding of the place of white people and of colored people in society? That the white people are on top and everybody else is below, and that the reason that someone who is 1/8 colored will be in the colored car is that they are impure?
no, I think that it's often the case that minorities in society are discriminated against. Jews, for instance, are 2% of world population. I don't actually know what the percentage was at this time, but they're the largest share of hate crimes are directly against Jews.
How's that relevant?
A minority group can be discriminated against.
Oh, sure, but.
That doesn't
but-
mean that necessarily in this case, the whites are the ones being discriminated against, but there's no,
Whites aren't
Land of inferiority.
a literal minority here, but they are a more exclusive group in that it is a much narrower set of people that can go into the white train car. Someone with higher than 87.5% white blood is a why is it that someone who is 1/8 colored is considered colored?
because that's the provision that the law sets out.
Right, but is that not placing a brand of inferiority on, for example, does that not place a brand of inferiority on Plessy as compared to any other white man who looks just like him?
No, it doesn't, because the law, the trains are equal. Whether they're enforced equally or not, they're equal in the law. The law requires that the trains be equal, so there's no inferiority.
Can we talk about equal? I want to talk about, you say that the police are not making arbitrary distinctions, but you do say that racial distinction is arbitrary. So I'm wondering where you get that. If you believe that racial distinction is arbitrary, why are these decisions that the police officer or the attorney general is making not
I
arbitrary?
think we're confusing two definitions of arbitrary here, two sides. One is a distinction, like racial distinctions are arbitrary, they're not based on any fact or any like scientifically proven fact, but arbitrary decisions are decisions that are not based, the police don't have arbitrary power to decide. Their decisions have to be based in the law.
But if someone like, say, Plessy, is not clearly presenting as black, and were to sit in the white car and no one noticed, isn't that an arbitrary distinction, right? To say that like, oh, Plessy's okay because I can't tell that he's black. But this other guy, who's equally as black under the law as Plessy, is not okay.
Plessy's not okay.
But let's say that someone who looks like Plessy and is 1/8 black sits in the white car and no one kicks them out. But then someone else who is the same under the law, is black under the law, walks into the car but is more noticeably black, they're more likely to be kicked out of the car. Isn't that an arbitrary distinction? Because they're both equally black under the law.
No, but that's in the enforcement. It's possible that Plessy, someone who's 1/8 black, is equally liable under the law. They are equally required to sit in the black car.
But they're not equally as likely for it to be enforced for them.
I don't think
Isn't that problematic?
I don't think that's relevant.
So some
I think
people are better at getting away with
train-
murder and
That's what the
something.
case is.
Exactly.
How is it not relevant? How is the fact that he's less likely to be less likely to be kicked out just because of his white appearance, so to speak. How is that not relevant? How is the enforcement irrelevant from this
Some
case?
people look less like murderers.
But that
They're
seems
less
to,
likely.
He just has an advantage in breaking this law more easily than
but
others.
isn't that an exact example of arbitrary enforcement? The officer is the person that is responsible for enforcing this law. And if they are not enforcing it because of just simply the way someone looks, isn't that an example of arbitrary enforcement?
All laws come down to a group of people who have to make decisions.
Right.
If any law can be enforced arbitrarily, any law you can, without argument, any law is arbitrary. A driver's licenses are arbitrary because the person sitting in the car for the driver's test can decide, gets to choose.
Right,
So if the law was
But they don't
modified to
have
have,
arbitrary power.
Let me ask a question, right? So the driver's test has a thing like I have to do a 3-point turn, and there's a way that I execute a 3-point turn that is to the standard that will get me my driver's license. But here, there's no the line is much fuzzier, right? There's no like if I do this and this, then the law is going to apply to me. The law seems to be much more arbitrary. Do you understand what I'm saying?
In what way? What part of it is arbitrary?
That it is making this racial distinction.
so what,
That
so
distinction is very clear.
the distinction isn't arbitrary, it's just that some, with your naked eye, you can't automatically know whether someone is 1/8 black or not. My question for you is, what, if the law was modified and everyone had to carry around a card saying whether they were qualified as colored or white
That's like-
for the train cars, would that make it better? Would that suddenly make this law constitutional for you? Because I don't think this is the main constitutional question here.
The card carrying.
See, I do think it matters.
Hold, wait,
because-
I just want to remind you guys that that you can do this part of it afterwards. You have lawyers here to, you know.
The problem for me is not just the arbitrariness of the law, it's that the wording is causing the arbitrariness. Do you understand what I'm saying?
What part of the wording is causing that?
That because the wording of the law sets up this racial divide, it's causing the arbitrariness.
I don't understand what you're saying.
That because the law is racially dividing, it's causing the arbitrariness. It's not like the arbitrariness is just happening.
How?
The inherently making a racial divide will cause the law to be more arbitrary than an average law.
And
I don't think that's true. Is the making a divide between, I mean, we have also established that in Strato v. West Virginia that you can make a law. The laws, race does matter when you're making laws. So you
Right, but I
have
think
to.
Strouder is a very different case in terms of race. I'm not saying that no law can consider race, but I'm saying the way that this specific law considers race creates this opportunity for arbitrary discrimination. Would you disagree?
I don't, yes, I would disagree, because ultimately, the train cars are set out to be equal in the law. So, whether or not a passenger is more arbitrarily chosen, although for one train car or the other, doesn't end up to ultimately affect the situation.
But let's talk about enforcement for a second. I'll ask you the same question I asked the petitioners. If we're drawing parallels between Yickwo and Plessy, what would be the equivalent of the Board of Supervisors as the executing or enforcing body of this law?
There is no equivalent,
There's no equivalent. Why not?
because there's no power that there's no group that is vested with arbitrary power.
But I think he's
But
asking who's enforcing
I wasn't
the
asking
law.
about the arbitrary aspect, I was asking about who is not, take out the arbitrary question for a second, don't worry, I'll get to that. What power, like the Board of Supervisors, is the power delegated to execute the word of the rule of law?
I don't think there is an analogous power in this case, because there's no delegated group
Who's enforcing
delegated
it?
power.
Okay.
Well, in the Board of Supervisors is not enforcing the law in Yickwo. It's the policemen who go to
The Board of Supervisors is a body,
They
they
carry
decide
out
who gets a permit.
Okay, the
but
Board of
doesn't
Supervisors
But they're
decides who gets a permit,
Just like
who
in a-
decides who goes in which train
The
car.
officer.
There we go.
Okay, so my question regarding that, usually, when there's a law and there are multiple provisions under the law, each provision should be enforced equally. Why is the clause about the quality of the cars not enforced, while the clause of separateness enforced, and why is there no fine in the Separate Car Act for officers who
there
vi-
is.
there's a clause for officers who violate the equality of
Yes.
the cars?
Yeah,
Well, there's
they
a, yes,
purposely send
Section
people
3.
to.
it's both,
Could
it's
you
both.
read that?
That all officers and directors of railroad companies that shall refuse or neglect to comply with the provisions and requirements of this act. So that's all the provisions and requirements.
Are officers, but does it
Shall be
say anywhere that
deemed
officers are
guilty of a
responsible for keeping the cars equal? Who is responsible for keeping the cars equal? Because officers are obviously responsible for letting someone on or forcing someone out of any given train car, but
The officers and directors of the railway companies.
they're keeping
They
the
must-
cars equal?
Yes, they are,
It's their responsibility to clean the cars?
yeah, they have to keep the cars equal. They have to comply with all the provisions of the law.
Okay.
I have a question.
Yeah.
You talk about separate but equal and whether separate but equal is inherently unequal. When considering that question, do you think it's important to consider context? Like the context of the Jim Crow South? Do you think that matters?
I think that's anachronistic,
How's that?
because this is like the beginning of Jim Crow South.
We're still in the Jim Crow South. There have been black codes passed in the past. In the context that Plessy is in, does that matter? Is if separated but equal is inherently unequal?
I think it's possibly relevant, but I don't think it affects the ruling in this case.
So you don't think it
Oh.
should affect the ruling?
I don't think it does.
I think though, I personally believe that for a law to be constitutional, there needs to be a path to redress for someone who is wronged by a breaking of the law. So for example, if someone is murdered, that's illegal under whatever law says murder is illegal, and the victims, the family of the murdered victim, then have a path to redress in courts. Is there a path to redress here for someone like Plessy or anybody else who experiences unequal enforcement of the law on the part of officers?
I don't know if it's necessarily unconstitutional if that doesn't exist.
But is there a path?
Is there a path to redress?
I don't know.
I guess it was kind of a rhetorical question.
Yeah.
I can answer for you. The answer is no. The private lit- yeah, it was it's a lawyer question. The private
How can they help you?
Yeah.
Okay, so I'll tell you what I know, and you can help me figure something out. So, the private litigants don't have a right of action in this case. The only person who has the right to sue anybody in relation to breaking the Separate Car Act is the Attorney General of the state of Louisiana, who is responsible for enforcing the laws of Louisiana when they are broken. So, is it problematic that the Attorney General is selectively enforcing parts of the law and not other parts when they have full discretion to decide which laws to enforce?
It is problematic for the Attorney General to be enforcing different parts of the law and not others. However, the Attorney General is acting unconstitutionally and outside of his, is not upholding the responsibilities of his office.
The
His
Attorney
You
law
can do
is
that
not
with
at
any
fault.
law.
The Attorney General is acting unconstitutionally by enforcing one part of the law and not another part of the same law?
Yes.
Okay.
Well, he's not complying with the responsibilities.
And
of his
is
office.
the fact that this is a broad trend, that is not a single Attorney General, this is happening across the United States. I have never heard of a single, that doesn't mean it doesn't exist, but I haven't found a single case in which a state Attorney General has sued a private corporate or a private or state partially owned, whatever, has sued any corporation for being in violation of the equal part of separate but equal laws, and there's continued evidence that the same thing with KKK riots and lynchings. There's no enforcement on the part of the Attorney General. Does this not show that there is some consistent bias in Attorney General offices, and that there
Exactly.
needs to be some path created for redress by this court?
Misleading question.
No, it doesn't. There's the law is neutral and constitutional, so we shouldn't hold the law responsible for the actions of the Attorney General.
So I would extend. Here's what I'll say what I told the petitioners as well. I'm considering extending YICWO which says, you quote right here, the law seems intended to confer and actually to confer not a discretion to be exercised upon a consideration of the circumstances of each case, but a naked and arbitrary power to give or withhold consent not only as to places but as to persons. Does the Attorney General not have that same sort of discretion as they do in YICWO?
No,
Why not?
because they're responsible to the law, to the provisions of the law.
Right, but they have the same discretion to decide who.
They have the same discretion to break the law.
Tell me, okay, would it be problematic precedent to extend this YICWO to attorney generals?
I think it would.
Can you give me an example really quickly?
Because that means that, supposes Attorney General were to refuse to enforce some other law.
No, but no. They would need to be enforcing only part of it.
Okay, so let's, you can come back, you'll have time with them again, so make sure that if you have something you wanna follow up on, write it down.
Can we ask them more questions?
Yeah, so so each side's gonna have 3 more minutes, so, set 3 for.
Do they start?
It's their court, I mean, they're the ones who have to
It's
make
our
decisions, so
discretion.
they can use those 3 minutes as they see fit. But they are here to help you, so obviously use them to do that.
I have a question.
Hold on one second, okay, go.
So you claim that there is no consequence for the officer involved, and they claim that there is. Can you provide me with evidence that there is?
Well, when the train companies did not want to enforce this law, and they were highly against it because they thought they were going to be sued by the public. So they ratified the law. And if you want to look back at the law, it's in the add-on to this law, which says that the officers cannot be held responsible. I don't have the law open, but the officers cannot be sued by the public for this.
So we know that there's
Yeah.
no private right of action
But
for
they-
private
but they-
litigants, but it's not that they can have whatever action they can do whatever they want. They're still liable to
There are
prosecution.
consequences.
There are consequences, and they're liable to prosecution on the part of the Attorney General.
Do you think that matters?
The fact that they can be sued by the Attorney General.
Or the fact that in one of my respondents' briefs, it says that they can be fined $25? Because you did bring up that the officer doesn't have consequences multiple times, so I'm wondering
So I'm
if that
asking
matters.
because we know the train cars were unequal. So we know the train cars are unequal, and the state never did anything at all to litigate the train companies on that grounds. So obviously the Attorney General is not going to be following the state's own law, and really in effect there is no recourse for this.
I'm just gonna add on to that and say that there is a consequence for the train officer if they fail to comply with separating black people and white people, but that separation is based on their own discretion, and I think we're trying to argue that that's unconstitutional. Of course, if they don't enforce separate but equal, then there will be consequences for them.
I believe we have to look at, as YICWO states, is the law applied and administered with an evil eye and unequal hand? Because in that case, it's unconstitutional. And I will say there's nothing other than an evil eye in this administration, in the administration of this law.
Who's administering?
The state and the train companies and the Attorney General all have evil eyes.
Can I ask you a question about
arbitrary.
YICWO?
Yeah.
So in YICWO, it says that the nature of the law in YICWO caused that, right? Do you understand what I'm saying? Do you think that the nature of the law in Plessy is causing that equal eye and unequal hand?
Yes, from the legislators, we
100%.
can definitely make that assumption.
You can even see that they are. That most of the legislature are white supremacists.
No, but I'm asking like the wording of the law, do you think is causing it?
Yes. Look at our pictures. This is the
Beautiful.
effect. For you, stop.
All right,
Wow.
so we have 3 minutes to put on the clock, thank
See
you.
what the effect is.
It's like cartoon, it's not a picture.
You can.
If there are no pictures.
You can take whatever you wish, but let's have turn our attention please to our 3 minutes for the respondents. Okay, wait, started. Okay,
No, it's not.
focus, respondents. Chaim, you ready? Okay, respondents.
Do you want? Okay. We were cut off. Do you want? Have you thought of any?
I thought
any-
of something.
Okay.
Suppose a law existed that law that prohibited the consumption of alcohol except in small amounts, where such a or prohibited the possession of alcohol except in small amounts where such a possession was required by a person's religious practice. If the Attorney General that law could be made unconstitutional simply because the Attorney General doesn't enforce the second part of the law.
What's that? Repeat what the second part is, sorry?
That except in prohibition of possession of alcohol
Except
except in
small amount.
except in small amounts as required by
Religion.
a religious practice.
Got it, okay. So I think the difference would be here that at stake is whether the 14th Amendment is violated or not for individuals. And
The First Amendment is at stake.
First Amendment?
First Amendment?
Oh, freedom of religion, you're saying?
Yes.
I understand.
While you think about that, can I ask
Yeah.
a different question?
Go for
Okay, the petitioners argued that the law is responsible for its social consequences. Do you agree?
Yes and no. I think that the law is not responsible for the social results. So no, I don't think it's responsible for the social consequences. It's possible that it's responsible for its legal consequences.
Right, but you
But
don't
not
think it's
social
responsible.
consequences. Because the conflict between the races is not unconstitutional. Social conflict between the groups of people is not unconstitutional.
Do you guys mind if we go back to the alcohol example? So if the yeah, never mind.
All right,
I'll choose my room.
great. Okay, so petitioners and respondents, please pick your things up and move them to, I'll actually clear out so you can sit here around the table. That, by the way, was outstanding oral argument on everybody's part.
Good work.
Justices, you now will have about 10 minutes that you guys
Wow,
can
that's good.
use to discuss. And I'm particularly curious from the team 1 or team 2 actually. I think we switched up, right? So
Yeah.
from team 2 who presented last time, and we can just as you listen to the justices, listen to our arguments, listen to the justices. Are you thinking about your case differently as a result of hearing this particular case? So that's my question for the team that did not participate today, or did not rather argue today.
Are you still sitting?
No, I'm gonna move so you can stay.
Think we want?
Yeah.
Oh boy.
Okay. Emily, you can sit there. I think it's yeah.
No?
All right. So the way we'll do it, just start by doing a straw poll around. So each of you will tell where you are, where you're holding now, and a sentence as to why, and then you can begin your discussion. So why don't we start with Matt? Don't tell me, tell your fellow.
No, I don't.
You wanna abstain and then come back to you?
Alright.
Okay, so Sophie?
Plussy, I think I'm still a little bit plussy. Just because of the precedent cases and because I do think context matters, but I'm very interested by the respondent's interpretation of the quote, and I wanna think about it.
Yeah, give me a second. I don't think so
Yeah, you're not being held to this, just where.
yet. Yeah, no, I don't wanna say, I don't wanna
Alright,
sway.
okay, so, Max, do you have an opinion?
I mean, I've always been, like, from the beginning, I've always leaned towards Plessy.
Okay, and has your mind changed?
I mean, I wouldn't say I was, like, now I'm leaning less towards Plessy, but I haven't been, but my views haven't exactly been, like, completely, like, changed over to the side of Ferguson.
Alright, work it
So
out
I'm
amongst
still-
yourselves.
Why? What's the core issue for you?
I mean, the whole idea of like whether or not the enforcement of a law deems it unconstitutional, and how the respondents argue that. So for me, I just have to,
Yeah, I just wanna know what you're feeling.
I think it comes down to the alcohol question. I think that honestly is the core of the case. I don't think that there's any other I think another compelling argument was the branding, but I don't the idea that separation of the races and the way it was done was inherently a branding on the part of the law. I'm not sure that's as compelling as it is in Strouder, because in Strouder, obviously it's better if you are qualified to be on a jury. That is superior to if you are not allowed to be on a jury. That is like inherently a higher status. Whereas the rule of law, there's not an inherently higher status for purebred whites as opposed to everybody else, though with context. I would have to decide how much context I want to look at, but I don't think that's the core question. I think really the true core question is the question of redress, and can somebody who felt I was in an unequal trade part, can they attain redress? And the answer really is they can't. Now, is that problematic? And I want to skip to what Elon was saying with the alcohol example. And I think that the alcohol example is interesting because it also there are two parts of the law, and if only one part is enforced, that is a violation of someone's constitutional rights. However, I'm not sure that the alcohol example is pertinent. Is that the word?
That makes sense in the context of what you're saying, yes.
Because if you are only to enforce the prohibition aspect of Elon's proposed law, and someone who was drinking alcohol for religious purposes were to be arrested by state officials, they would be able to appeal that law to a higher power and revert and
Right, no, I get what you're
Yeah.
saying.
no, wait, but now I'm not.
No,
But that would be
makes
the
sense.
same thing as Plessy. That would be the same thing as
But Plessy has no way of doing it.
no, but
No,
Plessy
he's
got
saying
the
that Plessy
Supreme
was
Court
arrested and appealed the case.
Oh.
because only one part was. Okay.
Right,
If
Plessy had to intentionally violate the law in order for that to happen.
Right.
And in the alcohol example, you wouldn't be intentionally violating the law. I don't know if that matters to you,
right.
but you would be in the clear under the law, and Plessy is not in the clear under the law. His arrest was legal.
Yeah, and I think that works also. Yeah.
I'm gonna have to unpack this a little more, but
One thing I'm
I think that's the core
intrigued
question.
by is that it says it leaves no room for the people enforcing it to legally discriminate. And I don't know if it matters
true.
to me that the things the Attorney General's office is doing are somewhat technically illegal. I'm intrigued
But
by
is there, but you can't, I think that in an era where we haven't seen a single time, not a single time, that the Attorney General sues somebody,
Right.
sues
It's
a
just not
company
gonna
for
happen.
violating the equal aspect of, it is, there was a word that I used, I forgot what it's called. Selective enforcement.
Right, so
of-
stop, if, like, we take this case out of context, and we take it out of the context of, like, none of these cars are ever gonna be equal.
Yeah.
Which is the reality of the case, then do you think the law is constitutional?
No.
It's not about whether the cars are equal, it's about whether the Attorney General.
But if we
will
take it out of the
enforce equal.
context of there is no redress, if we take it out of the context of it's never going to be enforced,
Mhm.
right? If we take it out of that context, then is the law constitutional?
Yeah,
No.
Okay.
but I think
Why
context
do you
is
think
important.
that?
Well, wait.
I mean, I agree with you, context is important, but why do you
Yeah, I
think
wanna
that?
hear from Mike.
If the law were, if the cars were never to be equal, that would.
So I'm
I'd
saying
say-
if we take it out of the context of the Attorney General is never going to enforce this properly. Like, these cars are never going to be equal, that's just the reality here. Like, if we take it out of that context, if we say that there is redress and they are going to be equal in some, other world, then is the law constitutional?
If they are going to be equal and there is room for redress,
Yeah,
I
that is the law
feel,
constitutional.
I'd say yes, it is.
It is constitutional? So that's what I said. What do you guys, if, I don't know what you guys are gonna base your rulings on, but if I'm going to rule for Plessy, it'll be because of Yiquo, and it'll be because of this extension of Yiquo to the Attorney General. Does that set problematic precedent? What do you think of Elon's example or of other examples
I
potentially
mean,
in
my
which it
only
sets
worry about
problematic-
problematic precedent is that in some cases, you choose not to prosecute people
Mhm.
for various reasons, like there could be a reason that you choose not to prosecute someone, and my worry would be that that could become problematic, you know what I mean?
Sure, but this is a systematic, cross-state.
Right, that's the thing, so
uh,
it's a different kind of thing. But I do see that as maybe a little bit of a problem, is that what if you choose not to prosecute someone because, I don't know, for whatever reason?
Do you think the problematicness,
There you go.
I don't know if that's a word,
How about just problem?
that problem outweighs ruling for Plessy?
No, I don't think so, because if I think about it, for prosecuting someone, you have to meet certain requirements, right? So that,
In order to prosecute someone, there needs to be a certain level of
right,
you can- right.
evidentiary,
Sure.
okay, yeah.
So what would that
So
ruling,
why
what
is
would that
why
ruling
is
look
why'd you
like?
bring that up?
I
Sorry.
don't know, I just brought it up because I was thinking through, if you were to let someone off because, because they were a kid, or because
Sure.
you knew about surrounding circumstances, if you chose not to prosecute, that someone could see that as an extension of this.
Right. Yeah, no, I get it, but I don't know. Are justices allowed in their ruling to define the scope of their precedent?
I mean, yeah, I mean,
You could try.
So I
you
would-
can
I
try,
would-
yeah,
I
you
would
can
tr-
try, I mean, you're right.
I don't know, I'm gonna have to grapple with the alcohol content.
I mean, justices are always mindful of what they're writing as potentially, which is why most of them, some of them like writing broad rulings, but most justices try to write as narrow a ruling as possible so they don't get into that precedent kind of problem. But you can write a broad ruling.
When you thinking about this, do you ever think about the impact that it's gonna have? Do you ever think about what this means for public schools?
No. What do you think, Max? What are you leaning?
At this point, I mean, a little, in some ways towards Ferguson, in some ways towards Plessy.
All right, inconclusive. We'll have to hash it out.
Yeah.
What would you say? That was funny.
Leaning Plessy.
Yeah, Sophie?
Silly and classic.
So we have two.
Heavily.
So we have two Plessies and Ferguson. Did you say Ferguson, Max? Is
Unclear. I
You're
think,
unclear.
It's entirely possible
Small
that it
little
changes
toys,
when I write
classic.
my ruling though.
So can I just ask, I just want to ask the